Good morning. I'd like to call the meeting of the House Children and Youth Committee to order. Just a reminder to mute your cell phones, and if you're speaking, please turn on the microphone. Today we'll be voting on one bill, House Bill 350, sponsored by Representative Sanchez. The bill will establish the Uniform Parentage Act. The Uniform Parentage Act was drafted based on the Uniform Law Commission's updated language from 2017, which modernizes parental laws, extending protections to children born through surrogacy and assisted reproductive technology. To get started, Brooke, would you take the roll?
Chair McNeil,
Here.
Representatives Bellman, here. Boyd,
On leave.
Serrato,
Here.
Curry,
Designation.
Fleming,
Designation.
Genst,
Here.
Hambidge,
Here.
Howard,
Here.
Kazim,
Designation.
Krajewski, McAndrew,
Designation.
Nelson,
Designation.
Parker,
Designation.
Chair Clunk,
Here.
Reps Barger,
Here.
Day,
Here.
Flick,
Here.
Hogan,
Here.
Kozak,
Here.
McKenzie,
Here.
Mihalik,
Designation.
Pugh,
Here.
Schlegel,
Designation.
Walsh,
Here.
Zimmerman.
Designation.
You have a quorum.
Thank you. The chair calls up House Bill 350, printers number 1276. Danielle, please provide a summary of the bill.
Good morning. House Bill 350, sponsored by Representative Sanchez, establishes the Uniform Parentage Act. The following third-party interest groups support this legislation: the Pennsylvania Bar Association and the Philadelphia Bar Association. The following third-party interest group is neutral on this legislation: the Pennsylvania Council of Children, Youth, and Family Services. There is no known opposition.
Thank you, Danielle. I'll be offering Amendment A01015. Danielle, please provide summary of the amendment.
Amendment A01015, sponsored by Representative McNeil, makes the following changes. The change to page 18 of the bill was requested by the Department of Human Services to conform the use of the word child care to existing Pennsylvania child-related statutes. The changes to pages 81 through 84 of the bill reflect a compromise reached with the U.S. Donor Conceived Council, or USDCC, to remove current language in the bill that allows a donor to opt out of an identity disclosure. Bill would then be silent as to this issue, allowing donors to make that decision with the fertility clinics and banks that they donate to. With this change, the USDCC supports the bill.
Thank you, Danielle. Will the committee agree to the amendment? On that question, I recognize Chair Clunk.
Thank you, Chairwoman McNeil. I will be supporting this amendment. I appreciate the makers of the bill working with the Donor Conceived Council on this particular amendment. I do believe that there is some room for improvement with this particular part of the bill, but I do appreciate your willingness to be open to some of their concerns, and I will be supporting it. Thank you.
Thank you. I'd like to note that Representative Fleming is in attendance. Those who are in favor of the amendment will vote aye. Those opposed, no. Brooke, please call the roll.
Chair McNeil,
Yes.
Representatives Bellman,
Aye.
Boyd,
On leave.
Serrato,
Aye.
Curry,
Designation. Yes.
Fleming,
Yes.
Genst,
Yes.
Hambidge,
Yes.
Howard,
Yes.
Kazim,
Designation, yes.
Krajewski,
Yes.
McAndrew,
Designation, yes.
Nelson,
Designation, yes.
Parker,
Designation, yes.
Chair Clunk,
Yes.
Representatives Barger,
Yes.
Day,
Yes.
Flick,
Yes.
Hogan,
Yes.
Kozak,
Yes.
McKenzie,
Yes.
Mihalik,
Designation, yes.
Pugh,
Yes.
Schlegel,
Designation, yes.
Walsh,
Yes.
Zimmerman.
Designation, yes.
The ayes are 24 and the 26 and the nays are 0. I'd like to call up Representative Delosier if you'd like to speak on the bill.
Thank you very much to the committee and Chair McNeil and Chair Klunk. Thank you very much for having this bill called up. Also, working with my colleague on this issue, Representative Sanchez, the ability to move this bill forward. I look forward to having a lot of discussion. We've had a lot of conversations, and honestly, this bill, when we've had those conversations, is to do one thing. It's about families. It's about the ability to say if someone is the intended parent, that parent does have rights in the eyes of the court. And the ability for us to respond to our court system who requested this clarification by us, I think that's when government is working together with two branches of government. The judicial branch feels that there is a gap in the law to allow for intended parents. Those, as you know, this started with a couple that used IVF and then divorced before the child was born. And one parent was not biologically the parent of the child that was to be born to this couple. That's what started this recognition of a gap in the law, and that is what this bill is aimed at solving. So allowing that an intended parent of a child has rights in that child's life, and that be a part of that child's life. So I believe that is something that the courts have asked for. That is something that our children, when they are older, will ask for, since this obviously happens when a child is a newborn or very, very young and can't speak for themselves. And so on behalf of that child, I think it's up to us and incumbent on us to allow for an easier pathway, that who is their parents and who is there to care for them in their lives. So that was the objective of this, the sole objective of this bill, and I appreciate any consideration and ask for your support. Thank you.
Thank you, Representative. I'd like to note that Representative Nelson is in attendance, and now Representative Sanchez would like to present some remarks.
Thank you, Chair McNeil, and thank you to my colleague and co-prime sponsor, Representative Delosier, who articulated that very well. And I just want to add a few additional comments and kind of sum up the bill, because I know it's a lot, and I want to thank both of the Children and Youth chairs, Chair McNeil and Chair Klunk, and of course Executive Director Bowers, for putting this all together, hearing the bill, and also having the hearing a few weeks ago that I know many of you attended and or received the testimony for, which hopefully answered a lot of questions. Again, I know this bill is big, many pages, and a lot of things, so just want to try to encapsulate that a little bit. And many of my comments are informed by the Pennsylvania Bar Association and, of course, the Uniform Law Commission, who are both assisting with this process in a very in-depth way. So legal parentage, the topic here, which is the recognition under law of the parent-child relationship, is one of the most important and foundational determinations there is in the context of family law. Knowing that you have the legal status of being someone's child or someone's parent, with all the rights and responsibilities that come with that, is foundational not only to the family unit, but to who we are and who we become as people. Legal clarity on the question of who is a parent is not just important, it's necessary. We have laws determining who are the parents under all kinds of different situations, and many of these laws go back hundreds of years. For the most part, those laws are still serving us pretty well, but one area in which the law has not kept up with the reality of how families are created is assisted reproductive technologies, or as I'll refer to them in short, ART. Generally speaking, we're talking about in vitro fertilization, sperm and egg donation, and surrogacy. House Bill 350 would set forth clear guidelines for people who are trying to become parents, for surrogates and for gamete donors when ART are utilized to conceive a child. As many of you know, this is already happening every day in Pennsylvania. To put it plainly, this bill will make clear who the legal parent is and who the legal parent is not when a child is conceived and born with the use of donated gametes and or with a surrogate. Currently, sparse judicial guidance across the Commonwealth has led to confusion for judges, attorneys, and families who must navigate this foggy legal terrain. The case law that does exist on this topic can be helpful, but since each case has a specific set of facts, not every legal outcome will apply to every family scenario. This leads to lengthy and expensive legal processes for Pennsylvania families, as well as a great deal of stress and uncertainty and a potential lack of the ability to plan. Adopting House Bill 350 will greatly improve the legal landscape that families, attorneys, and judges must navigate where disputes arise involving children born through ART. And I want to emphasize, this bill does not do any of the following. It does not do this. It does not change custody laws, does not eliminate or undermine how people are currently recognized as legal parents. It does not make surrogacy legal because it already is legal. It does not make IVF legal because IVF already is legal. It does not make egg or sperm donation legal because that already is also is already legal. So what the bill does do is make it clear who the legal parent is in situations where a child was conceived using ART. It does reduce, or it will reduce, litigation, stress, and uncertainty for families. It will establish guardrails for the use of surrogacy and gamete donors, and it will provide clear legal guidance on all of these matters. And just a few more capstone points I'd like to emphasize. This is a pro-family bill. Children deserve to know who their parents are and not have that question in legal limbo, and this bill provides that stability. The parents of children conceived through ART are the individuals who planned, prepared, and took on the financial responsibility to conceive and raise the child as their own, and this bill provides that clarity. The bill promotes legal consistency across the Commonwealth of Pennsylvania. The bill will reduce litigation, and the bill creates legal guardrails around surrogacy agreements, both in terms of what must be in a surrogacy agreement and what cannot legally be in the agreement. It helps people who struggle with infertility and want to build families, and the bill will reduce the likelihood of disputes and provides for a fair and appropriate way to settle disputes where they do occur. And I thank you all again for your time and for listening, and hope that you can support this important bill. Thank you.
Thank you, Representative Sanchez. The question recurs, will the committee report the bill as amended? Representative Barger?
Thank you, Chairwoman McNeil. I appreciate it. I wanted to point out that, obviously this is a tricky one. It's a long bill. There's no way to make this a short bill. There's too much going on there, and I do appreciate the intent of trying to provide clarity for Pennsylvania families. I wanted to articulate some of my concerns kind of at a macro level of why I think there are some objections in the pro-life community to this bill, and in hopes that if these concerns are addressed, it will help in the process of crafting a bill that does not only what it intends, but doesn't also create unintended consequences down the road. To me, that there are questions in this bill. It seems as though it's oriented towards the parents, which makes sense. What are your rights as a parent? But it's not oriented towards the well-being of the child, and that's concerning to me. What does it look like if, for children in these processes? I think one of the underlying concerns with IVF and surrogacy and those things in the pro-life community anyway is that it's tending to view children as commodities that are purchased, and then the people who purchase them have certain rights to those children, and people aren't commodities. People are human beings, and I think it's important to be able to articulate that. So I think that there is a lot of the questions that we have, and even sometimes not specific questions with language of the bill, but kind of uneasiness with the topic of IVF, the topic of surrogacy, comes from the fact that we have not the entire conversation of IVF, surrogacy, parentage presumes answers to questions that really haven't been answered yet. And I think that's where a lot of the confusion and uneasiness comes from. It presumes that we've answered specifically this question: at what point does an unborn baby become human enough to have the right to stay alive? And there is obviously a broad spectrum of opinions on the answer to that question. But all of these things, as well-intended as they are, I love to see more families in Pennsylvania. But these intentions, these processes, this bill, in fact, presume that that question has been answered satisfactorily, and I don't think it has. So this is why I think some of us in the pro-life community are uneasy about this bill. What I would like to see is us answer some of those questions, and I understand the bill doesn't get at the legality of IVF, and nor should it. I mean, that would turn the bill into an 800-page bill, right? And we would never get it done. But I do think that we need to ask those questions, because we're presuming just because it's legal that it's okay. We're presuming that just because we can do it scientifically, the technology is there for us to do it, that it's okay. And I just don't think that that's necessarily true. So I do appreciate the ability to speak, Chairwoman, today, to share those concerns, hoping to provide a little bit of context of why some of us in the pro-life community are concerned with this bill, and hopefully we can improve it and make it better as it moves forward. Thank you so much for your time.
Thank you. Chair Sanchez, do you want to respond, or do you want to wait to the end?
Did you want to say something?
Vice Chair, sorry.
Seems like there, you articulated it well, Representative Barger. I mean, there's probably a fundamental disagreement on the legality of certain things that underlie the bill, and I think you stated, and I don't want to put words in your mouth, but it doesn't really affect what's in this. So, I mean, I respect your statement, but obviously disagree and still believe in the need for this bill in Pennsylvania law, and appreciate your comments.
Thank you. I think it's important for us to, on our side, to understand this is, for you folks to understand, this is why we're uncomfortable with some of these things. And I'm not demanding that you yourself, as the sponsor of this bill, answer all these questions for me. This is kind of context of where we're coming from. Thank you.
And
Go ahead, Chair.
Sorry, Chairman. And all I would add, yeah, absolutely, and I'm on, we're in the same caucus and everything else, and those questions, and as Representative Sanchez mentioned, we have things that are legal here, and I understand philosophically, absolutely, you have to vote the way it is that you need to vote, and I totally respect that. What we are trying to do is respond to the courts, because they are making decisions every single day on this issue in family court, and they have a gap, and their hands are tied, where they cannot have a distinct decision or direction from the legislature. And so if something would change, as you were talking about with any of the underlying issues of if someone disagrees with IVF or disagrees with surrogacy or any of that, that absolutely is a debate that we can have. What we're trying to do is deal with what we have in front of us and how it exists right now with the courts, and respond to the courts as such. So thank you very much.
Thank you. Representative Walsh.
Thank you, Chairwoman McNeil. I just have a couple of questions regarding the language of the bill, and please correct me if I'm wrong on anything. I just have two questions. During an adoption, there's always an inquiry into the best interest of the child. But pursuant to the Uniform Parentage Act, a person or persons could become parents without any court inquiry into the best interest of the child. Am I missing something in the bill? Is that am I correct in saying that?
If you want to respond, you may.
I'm sorry.
What's that?
Your question.
Oh, yeah, I can. Well, during an adoption, there's always an inquiry into what is the best interest of the child, but pursuant to the Uniform Parentage Act, a person or persons could become parents without any court inquiry into the best interest of the child. And I'm just wondering if this is true, why is there a lower standard ignoring the best interest of a child here?
Want to be sure I understand the question entirely, but I don't know that it this changes anything in the adoption process, because it's not really changing the custody laws. So if that, it wouldn't prevent that inquiry by a court, and then at the, the stage of becoming a parent, the legal status of a parent, I mean, I'm not sure that inquiry applies outside of the adoption context either. Like if you were just having a child, there's not a court inquiry at that point. Am I making sense?
Okay.
And Representative, if there is a particular, are you pointing to a particular line in the bill that you're concerned about? Because nothing that in the bill at this point changes how a child is adopted, how someone is conceived through IVF, or the surrogacy laws. We're not touching any of those through how that process happens right now. Obviously, the intention or the benefit of the child, it should be paramount across the board. So if there is something that you're pointing to in particular in the bill, please, we're open to that, because our goal is the child. That is the priority. So if there is something in the bill in particular that you're pulling out, where you believe that there is a misstep or something like that, please, let us know, absolutely, and we're glad to have that conversation.
Okay. All right. And then I guess on that similar topic, prior to an adoption, there's always a home study and background check for adoptive parents. But pursuant to the Uniform Parentage Act, a person or persons could become parents without a home study or background check. And if you need a reference, it's Section 9802B in the bill. And again, this is something more that we can discuss offline. But those are two areas that I feel that just make me uncomfortable with the bill the way it's currently written. And you're more than welcome to respond if you want to, but I just wanted to.
No, that's
bring
fine,
up
and
those.
we're glad, we'll pull it up, absolutely. And if there's something that changes, like I said, the objective is not to make it easier or harder, in the sense of we're not changing how a child is adopted. The point of the bill is to say who are the parents of that child. There's no adoption necessarily involved, because we're talking about someone who was the intended parent all along, with the bill in and of itself. But glad to absolutely look at the particular section that's making you uncomfortable, and if there's something we can tweak on the floor, we're glad to do that.
Sure. Thank you.
Representative McKenzie.
Thank you very much for all the work that's gone into this situation. I'm very supportive of IVF and surrogacy, adoption, foster parenting, anything that brings children and good parents together and supports them. However, I do have a lot of questions concerning this, and I will be a no today. I just feel that, this struggle over who the parents is a age-old problem. If you remember the Bible story, of the two mothers and the king saying, who is the real parent, and cutting the child in half. So I'm not sure that this bill will solve the problems that humanity has in general about who the parents are. I will be a no today, but I appreciate the thought, and I love the idea of people who want children being able to have them and love them. Thank you.
Representative Flick.
Thank you, Chair. Thank you both. Obviously, this bill has a lot of emotion and passion, as you've already heard. I think just last week, an example would be my niece graduated from high school, which was a happy, happy event at age of 18. Just weeks after she was born, my brother-in-law, her father, was killed in Iraq. So 18 years later, and then she, of course, got a stepdad, which was wonderful, so that all worked out. But those types of things really it makes everybody think. Then some of his comrades went forward and donated sperm. And this was 2007 when we were having a lot of killed in action. So thank you for all the work and for covering those bases. My question is on page 9, line 28 through 30. I know, Rep. Sanchez, I know you mentioned that none of this changes custody laws. So my question is around that, and I'll read it to you. Petition for modification of a support order may be filed at any time and shall be granted if the requesting party demonstrates a substantial change in circumstances, which we just discussed a week or two ago in a different bill. I guess my question is, could you define what a substantial change in circumstances would be? And I have 3 examples if you want me to lead by example or if you want to open it up and have your thoughts. Okay, so example 1, let's say the father has custody and the mother has a drug and alcohol issue and she completes treatment court. Would that be considered a substantial change in circumstances? She's now clean. Could she ask for a modification of custody?
I would think that the court would take a look at it, and I don't want to misspeak. So if absolutely, if there's change in circumstances, we can absolutely clarify that and nail that down for you, because I know that that's very important. That's an issue that's very important to you, and you've advocated on it wholeheartedly. So if we could use your knowledge on that to clarify that,
Sure.
if that needs to be further clarified, we're glad to be able to do that.
And I appreciate that. I think some of the issue, I'll just throw 2 more examples out there to sort of round it out. Father changes jobs, so he wants to be closer to the kids. The court says, well, you're too far away, you're a truck driver, so he becomes an Uber driver in his own hometown. So that would be an example, whether that would be a change of circumstances, or a PFA was filed against one of the 2 parents, and the court then expunged that PFA. I would think that would be a change in circumstances.
Representative, and right now, the laws that are on the books for the change of circumstance, as far as I'm aware, we weren't modifying any of what the definition of the law on the book says a change of circumstance is. So the clarification that you're delineating with the 3 examples, to me, seem like they would fall under that. I don't know the statute right as well to be able to understand what it is. We're not changing anything that's already on the books. So if those 3 qualifications comply at this point as a change of circumstance, we're not modifying them, but if there needs to be something that's more clear within the bill, let's have that conversation and make sure that we can.
I think it's difficult to qualify because one judge is different from the next judge, and one judge may see one of these 3 examples as a change, and the next judge may not, or there could be a judge that is abusing discretion, abuse of power. So it's going to be hard to narrow this down, but again, I do appreciate your help, Chair. Thank you.
Okay.
Chairwoman Clunk. Sorry. Anyone else? Did I miss anyone? Thank you. Sorry.
Thank you, Chair Himbich. This bill is a tough one. There's a lot to this bill. I've gone back and forth in my own head. Am I for this bill or am I against this bill? And I will be honest with you, I still have serious reservations about this bill and will be working on filing amendments and continuing the conversations that we have had with the makers of the bill and the numerous interest groups that we've talked to over the past couple of months with this bill. I did want to note that there is a group that is in opposition to this bill. I know it was said earlier that there is no known opposition. There is opposition from the PA Family Council. They have provided us with some of their concerns in a particular memo, which I'm happy to get to any member that might not have that. Moving forward, I will be supporting this bill out of committee with the hopes that we can continue our discussions on some of the concerns that our interest groups have and that I personally have regarding the number of gametes and donation. what other states are doing on this, especially Colorado, I think is something that we can look to, especially when it comes to record retention from these clinics. What happens when a clinic closes? And that information that is very important, especially regarding medical information for these children, where does it go? Who has access to it? What if you're 5 and that clinic closes? Where does that information go? When you turn 18 and want to know if your biological mother had the BRCA gene, maybe you have the BRCA gene for cancer. What happens at that point? I think there's still a lot of discussions that we need to have on this bill. I still have some concerns regarding whether or not the child should know who their biological parents actually are. I am considering filing an amendment on that issue. I know we've discussed this at length. I do firmly believe that children should know who their biological mom and dad are. I think it helps define you as a person. It doesn't change the relationship that you have with your, maybe on the books, in the law, parents, but I think it helps form you as a person. And in talking with so many children and those adult children who are trying to figure out who they are as people, why they have the quirks that they do, why they have the hair color, the eye color that they do, I think that's important. I think that goes to a lot of the mental health concerns that we have in this world today of people just not knowing who they are as people. And that's certainly something that I think Colorado got right, that maybe we can look to in moving this bill forward. So please look for some amendments for me in continuing the discussions that we've had. I will be supporting this moving forward right now and moving forward with some hopeful potential amendments and discussions. And I truly want to appreciate the discussions that we've had so far on this. I know you are both coming from a place where you want to help families and you want to help children, and I believe that we can continue these discussions, so thank you.
Thank you, Chairwoman. I want to thank both of you for bringing forward this bill. I think it's really important that we create uniformity, that we create transparency, that we help courts, but most importantly, that we help families have some assurance. And I think that this will really help them. It will put us with 25 other states and having laws on the books that protect families. So thank you both, and I look forward to voting in favor of this. Brooke, could you please call the roll? Those in favor will vote aye. Those opposed, no.
Chair McNeil,
Designation, yes.
Representatives Bellman,
Yes.
Boyd,
On leave.
Serrato,
Yes.
Curry,
Designation, yes.
Fleming,
Designation, yes.
Genst, Chair Hambidge,
Yes.
Howard,
Yes.
Kazim,
Designation, yes.
Krajewski,
Designation, yes.
McAndrew,
Designation, yes.
Nelson, Parker,
Designation, yes.
Chair Klunk,
Yes.
Representatives Barger, Day,
No.
Flick,
Yes.
Hogan,
Yes.
Kozak,
No.
McKenzie,
No.
Mihalik,
Designation, yes.
Pugh,
Yes.
Schlegel,
Designation, no.
Walsh,
No.
Zimmerman.
Designation, no.
On the question, the ayes are 18 and the nays 7. The bill will be reported as amended. With no further business, we stand adjourned. Thank you.